Under the doctrine of imputed negligence, one person's negligence can be imputed or attributed to another person who was without personal fault. The highest court in Maryland considered whether to impute a driver's contributory negligence to the injured owner passenger after a car accident in Seaborne Worsley v. Mintiens. After ordering takeout for dinner, Victoria Seaborne Worsley and her husband drove to the restaurant to pick up their food in a car that Worsley individually owned. When they arrived, Worsley's husband parked the car in the travel lane of the parking lot, perpendicular to the accessible parking spaces by the takeout window. Then he got out of the car to retrieve the food while Worsley waited in the front passenger seat. Meanwhile, Jeffrey Mintiens was getting into his truck, which was parked opposite the accessible parking spaces. He reversed, hitting the passenger side of Worsley's car and injuring Worsley. Some 9 months after the accident, Worsley sued Mintiens for negligence in Maryland State Court, seeking compensation for her injuries. Mintiens argued that Worsley's husband was contributorily negligent for parking in the travel lane, not an actual parking space, and that his negligence should be imputed to Worsley. The trial court agreed. Maryland is a contributory negligence jurisdiction, meaning that Worsley was totally barred from recovery. The Intermediate Appellate Court affirmed, and Worsley appealed to the Maryland Court of Appeals.